Good morning, and thanks for joining us for a Tax Practitioners Board webinar. My name is Ashley Dowsard, and I'm hosting today's session. Today, I'm joining you from Ngunnawal and Ngambri country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters, and community. I would like to pay my respect to them and their cultures and elders, past and present. To begin, I have some quick housekeeping messages. First, to access today's slides, you can visit our webinar's resources hub at tpb.gov.au/webinar-hub. We'll also email you a copy of the slides following the webinar. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue an attendance certificate to those of you staying online for the webinar today. In today's webinar, we'll provide an overview of recent changes to the Tax Agent Services Act 2009, or TASA for short. We'll explain the new guidance on our 2 code items related to disqualified entities. We'll also go through a few scenarios and case studies before we dedicate some time at the end to answering your questions. In that regard, we have Daniel from our policy and legislation team joining us. He'll be responding to your questions as we go, so please submit them through the Q&A. To find the Q&A, hover your mouse over the screen and a range of icons will appear on the bottom of your screen. We'll be turning off the chat function throughout the presentation today, so if you need a response from us, be sure to use the Q&A. Before we begin, I'd like to introduce our speakers for today. TPB Chair Peter DeCure and Assistant Secretary Jeanette Liu. Welcome to you both. Peter, I'll hand over to you to get us started.
Thanks, Ashley. Good to be here this morning, and warm welcome to everybody that's joining us. Today, obviously, we're going to go through some quite detailed commentary about the changes, so I'll be referring pretty heavily to my notes. So if I look like I'm a bit stiff, I'm trying to make sure that we get everything right and communicate to you very clearly. So moving right into the changes, as you would all be aware, the government has made changes to the TASA a couple of times recently. In particular, the Treasury Laws Amendment Bill 2023 Measures No. 1 Act and the Treasury Laws Amendment Tax Accountability and Fairness Act of 2024 have amended the TASA, and there are some really important changes to take into account in the conduct of your practice going forward. These changes commenced earlier this year and include expanding the Code of Professional Conduct, or the Code, to prevent tax practitioners from employing or using a disqualified entity without our approval. It also prevents tax practitioners from entering into certain arrangements with a disqualified entity. Giving the minister the ability to expand the code to include additional obligations that tax practitioners must comply with to address emerging or existing behaviours and practices. Moving the registration period for tax practitioners from at least every 3 years to every year. And that's just in line with all your normal professional association requirements. There are self-reporting obligations whereby tax practitioners must notify us in writing if they have breached the code of conduct and if that breach is a significant breach. Practitioners must also report other practitioners by notifying us, the TPB, and their recognised professional association in writing if another tax practitioner has breached the code and that breach is a significant breach. A tax practitioner must notify both the TPB and professional associations in writing, and we'll talk a little bit about that later. Also, we're updating the objects clause of the TASA to recognise its role in supporting public trust and confidence in the integrity of the tax profession and the tax system. We're enhancing the TPB's financial independence from the ATO, allowing a separate funding for specified purposes. Our financial independence from the ATO is enhanced by establishing a special account for the TPB, making sure we have a separate line of funding for our own special purposes. Finally, we will ensure the board members who are appointed to the TPB going forward meet the definition of community representatives. Going forward to the next slide, we're also talking about the Treasury Laws Amendment and Fairness Act 2024 has made a number of changes in relation to the TASA and the Tax Administration Act of 1953. There's an extension of whistleblower protections to eligible whistleblowers who make disclosures to the TPB, as well as disclosures to other certain entities who may support or assist the whistleblower. There are public register changes that enable the publication of additional information that will appear on our TPB public register. There's an extension of the TPB's investigation period from 6 months to 24 months. And that really is for the major, most complex cases, not the day-to-day run-of-the-mill cases. There are new information sharing provisions with Treasury that will allow taxation officers and TPB officials to share protected information with Treasury officials in relation to misconduct arising out of breaches or suspected breaches of confidence by intermediaries engaging with the Commonwealth. And there are information sharing with prescribed disciplinary bodies. This will allow the ATO and TPB officials to share protected information with prescribed professional disciplinary bodies to enable them to perform their disciplinary functions more effectively. These changes are aimed at enhancing our effectiveness as a regulator and will assist us to strengthen community confidence in the integrity of the tax profession and the tax system. So let's turn our attention to the topic of the day, and that is disqualified entities. We've recently invited everybody in the profession and the public to submit feedback on our draft guidance. We've taken that feedback to account and we're now finalising our guidance and our position and have released our final guidance on our website. The guidance is there and available to you to help you understand how these laws will operate. I would like to thank those who provided feedback. We appreciate the contribution. I'm now going to hand over to Jeanette Liu to take you through some of these important updates.
Great, thanks Peter for that. And hello everyone, and thanks for joining us today for this webinar around disqualified entities. So look, I might get into the details of these two new code items, code item 15 and 16. So as you can see there on the slide, what code item 15 requires is that you cannot, as a tax practitioner, employ or use the services of another entity that you might know or ought to actually know is a disqualified entity to help you provide tax agent services unless you have approval from the TPB. There are quite a few concepts there, and we'll go through them in a moment, one by one. Now, in relation to code item 16, what this item prohibits is you entering into certain arrangements with another entity that you know, and again, ought to reasonably to know, is a disqualified entity in relation to the provision of tax services. Now, those two code items sound like a little bit of a mouthful. I appreciate that. And I think the easiest way that I try to explain the difference between these two code items is that under code item 15, you cannot, unless approved, use a disqualified entity. And in relation to code item 16, you can't actually be used by a disqualified entity. So hopefully that distinction helps with a bit of your understanding. But as we go through this webinar, hopefully that will become clearer. Now, before we move on, I do want to touch on the point around the concept of know or ought reasonably to know. It's really important that we understand these because it really is a basis and a grounding for how these two code items operate. So there are really two elements to that definition. The know part, which I think is fairly obvious, that's something where you have actual knowledge of. What is a bit more complex, though, is the idea or the concept of ought reasonably to know. Now, when we use that phrase, we define it to mean what a reasonable person in the same position as that person should know after they've made some reasonable inquiries. So it's a bit of a reasonable person test. So what this requires of you as a tax practitioner is taking reasonable steps and making reasonable inquiries to determine if someone is or is not a disqualified entity. But again, we'll talk through these points in more detail as they are somewhat interrelated. So I'll move on to the next concept that it's very important for us to all be on the same page about, and that is what is a disqualified entity. Now on the screen then, it's probably a little bit misleading. It probably should say what is an entity, but on the screen you can see a list of common entities. That includes individuals, companies, partnerships, trusts, etc. Now what you do not see on that list are registered tax agents, registered BAS agents, as well as qualified tax relevant providers. And that group are essentially financial advisors who can legally provide tax advice. Those three entities, I'll call it, are not on the list and therefore will never ever meet the definition of what is a disqualified entity. So that was a list of entities. The next slide that we have goes into what makes an entity a disqualified one. And it's whether or not one of these disqualifying events may have occurred. And the look back period we consider is in the last 5 years. So for you as a practitioner, you should be asking these questions and saying, have these things occurred in relation to someone that you are looking to engage or are seeking to be engaged by in that 5-year period? Now, it's all fairly clear on the slide what some of those disqualifying events are, but I might just quickly summarise a few of those. So it includes being convicted of a serious offence or a serious taxation offence, or an offence involving fraud or dishonesty. It also includes situations where someone has been penalised for being a promoter of a tax exploitation scheme, or perhaps implementing a product ruling that's not in conformance with what has been approved. It also includes other factors which I would like to say are fairly common sense. These are factors such as being an undischarged bankrupt, or perhaps an entity that's gone into external administration, someone that has contravened the TASA, has had action taken against them. It may be someone that was previously registered but has had the registration terminated, or perhaps their renewal rejection that might have been, their renewal application, rejected by us at the TPB. Now, importantly, on that last point, where someone has had their registration terminated or a renewal rejected, we only look at grounds that go to someone's integrity. So it might be in relation to their fitness and propriety. For example, sometimes we find that people can't get their registration renewed because they don't have enough relevant experience. In those cases, that does not trigger a disqualified entity event for the purposes of these provisions. So the next element that we have in relation to Code Item 15 is that we look at whether or not the entity that you're seeking to engage is someone that you're looking at employing or using. And that definition is quite wide. It includes not only what you would expect around employees, but it includes associates, contractors, as well as other individuals who might actually share in revenue and income received from your practice. Now, very, very importantly, Code Item 15 does not apply to entities that are providing administrative support, for example, people that might be doing back office services, secretariat services. And it doesn't also include anyone that is providing a tax agent service, but they're doing it for no fee or reward. They are not captured by Code Item 15. So hopefully that gives you a pretty good understanding of how Code Item 15 operates. If we move on to the next slide, if we could, Lun, we might look at how Code Item 16 operates. And once we've done that, we'll move on to discuss some of the more practical aspects of what you need to do as a practitioner to make sure that you comply with these two new code obligations. So as Peter mentioned right up front, the purpose of Code Item 16 is to prohibit you from entering into certain arrangements with a disqualified entity in relation to the provision of tax services. And really at the heart of Code Item 16, it was really intended to prevent arrangements where disqualified entities are operating through the registered tax practitioner. We have unfortunately seen situations which we call sort of tame agent situations. And what occurs in these cases is where the disqualified entity is actually operating as the controlling mind, and they're providing tax agent services while they're unregistered and using the registered tax practitioner's credentials, for example, to access OSFA. On ATO's online services for agents, for example. So it's about using the registered tax practitioner as a bit of a vehicle to essentially drive through unregistered behaviour through that registered tax practitioner. Now, many of the concepts in Part Item 16 we've already covered off before around, what's an entity, what's a disqualified entity, what is ought reasonably to know. So what I might do now is actually go into some more practical aspects around how you comply with Code Item 16. So if you want to enter into one of these arrangements with an entity, there are a few things that you need to do to satisfy yourself that you aren't going to be in contravention of this code item. So we've listed a few things that you will need to do. At a first level, we ask that you undertake POI checks. The TPB, we've got guidance as to what is required when it comes to proof of identity. So have a look at that guidance, but you do need to undertake these POI checks before you engage. We also ask that you seek written confirmation from that entity that's seeking to engage you that they haven't had one of those listed events occur in the last 5 years. So that was that previous slide that we showed with about sort of 10 or so events. The other thing that you'll need to do is to also search the TPB's public register, as well as ASIC's financial advisor register, to check on a few things. One, whether or not they are currently registered, and whether they previously were registered, and if so, whether or not they've had a sanction imposed on them. So there's a wealth of information there to help you undertake those first few steps. Now, unlike Code Item 15, which I'll talk about in more detail in a moment, arrangements under Code Item 16 are prohibited. So the TPB cannot approve these arrangements if you want to enter into it. They are simply not feasible and cannot occur. So if we look now at complying with this code item, we might look at a couple of situations actually to try to make it a bit more practical, hopefully, for you. So under situation 1, if you want to enter into an arrangement with an entity, you firstly need to undertake those checks that I just spoke about before. And where any red flags come up, you cannot enter into that arrangement. That is, at its most simplest level, how Code Item 16 operates. So this is when you're about to enter into an arrangement. You haven't yet. The next situation that we've got is you're a registered tax practitioner. You are already in an arrangement with an entity, and the entity is not a disqualified entity. So in relation to this situation where you're already in an arrangement and the entity is not a disqualified entity, so in this case, what you need to do is make sure that you have a written agreement in place to require notification by that entity to you as soon as possible if they were to have one of those disqualified entity events occur. And you also need to have a process in place that allows you to discontinue that engagement with them if they were to notify you that one of those events has occurred. The next situation is where you want to enter into an arrangement with someone that you know is a disqualified entity. And as I said before, these arrangements simply cannot be approved by the TPB, and the only way that you can comply with your obligations is to not enter into that arrangement at all. Now, the last situation I might cover off on in relation to code item 16 is where you have been engaged by an entity and they have notified you that they are disqualified, but for whatever reason, you want to continue with that engagement. As per that previous example we spoke to, the only way to comply is to cease that arrangement. Now, you might need to think about some of your legal obligations, including under contract or employment law in that case. So I might move on now to look at an example. So in this case, we have a situation where we got Kim, and Kim's registration was actually terminated by the TPB 9 months ago. And that's because Kim was not a fit and proper person. And so as a result of that, Kim is now a disqualified entity. Now, Kim wants to enter an arrangement with Matt, who's a tax agent, and that's so that she can use Matt's access to the ATO's online services to lodge returns, for example. Now, Matt himself as a tax agent, he is not involved in preparing or lodging those returns, and he actually doesn't have any contact with Kim's clients. In this situation, Matt receives a payment from Kim for allowing her to use his credentials to lodge. So in that case, it's very, very clear to us that, Matt didn't conduct any POI checks, and they definitely did not check the TPB public register, because if they had, they would have seen that Kim was sanctioned only 9 months ago. So in this case, Matt would actually be in breach of code item 16 if he went ahead and continued or started to engage Kim. Now, importantly, Matt might also be in breach of other code items that exist, such as honesty and integrity, which is a key one that we do consider when we look at disqualified entities. Now, Kim also might be in breach of the Tax Agent Services Act, and we'll talk more about this later, but there are actually obligations on the person or the entity that is disqualified to let you know of that status. So while there is a lot of responsibility for you to check, there's also responsibility on the disqualified entity to let you know. So we might continue talking now about some more of those practical steps about how you identify if someone is a disqualified entity. And earlier on, I spoke about taking reasonable steps and making reasonable inquiries if an entity that you employ or you use to provide tax agent services on your behalf is actually a disqualified entity. So the reasonable steps and inquiries that we would be asking you to undertake would be asking questions as part of the onboarding process for any new employees or other entities that you're seeking to bring on. We also ask that you have reporting processes and procedures in place that require employers to notify you, or there might be a contractual notification requirement for a contractor, for example, to tell you if one of those disqualifying entity events have occurred in relation to them. So at a very minimum, you should take these steps, but there are a few more that you need to consider. So I mentioned before, the first step is to check someone's registration status. So check if they were previously or are currently registered with the TPB or perhaps ASIC. That'll also let you know if they've been subject to a previous sanction. Now, as I said before, if you find someone's on our register or ASIC's register and they're showing as registered, they cannot be a disqualified entity at this time. And so therefore, these requirements we've spoken about will not apply in that situation. Now, after you've done these steps here in step 1, there are some additional steps that you should be considering. And this depends upon, I guess, the situation or where you are in the life cycle of engagement. It might be before you've actually engaged them, during your engagement, or maybe at the end when you're ceasing to engage that entity. So let's look at step 2. And this is a situation where you have not engaged someone just yet. I appreciate this might be a little bit repetitive, but these are really important points that really protect you and your practice. So we might just labor these issues just a little bit. So this is again before you employ or use someone. So we ask that you undertake appropriate proof of identity checks, and you can have a look at our own guidance, the TPB's guidance, which gives you a pretty easy checklist to look at to see what steps and what questions you should be asking. The next thing that you should do is to actually discuss the requirements of these 2 code items with someone that you're looking to engage or be engaged by, and actually seek written confirmation from them that they haven't had a disqualifying event occur within the last 5 years. Now, we have on our website a written confirmation declaration and consent form. Have a look at that. That's a nice, easy tool for you to obtain that written confirmation that you need from the entity. Now, for situations where you might be entering into a contractual arrangement, make sure that you have a written contract in place with that entity that does require them to notify you again if any of those events occur. It's also important that that contract or that arrangement makes it clear that where they do notify you, you've got options to cease engaging them immediately. Now, that has one qualification, which is you will need to be mindful around your obligations under the law, including under employment law. So the next scenario we'll look at is a situation where you've already engaged someone and during their employment or the use of that entity, they notify you that one of these disqualifying events have occurred. So essentially, you need to follow those steps we've mentioned earlier in steps 1 and 2, but it would probably already exclude the POI checks. And that's because you've already decided to engage them and they're already on board with you at that point in time. So that's fairly simple what you need to do at a situation where you have already engaged. Now, you do need to also consider that there are some transitional provisions which are currently in place. And I might talk about those now. We are currently in that transitional period, and that lasts for the entirety of the 2024 calendar year. And how you comply during the transitional period will again depend upon what stage you're at in terms of that engagement. Is it pre? Is it during, for example? And the reason why government put in these transitional arrangements was to give you reasonable time to comply, bearing in mind that you might be partway through an engagement at the moment, which might not be due for renewal in 2024. So let's look at those different scenarios now and see how it might apply during that transitional period. So firstly, we might just go back a slide if we can, Lynn. Firstly, if the contract was entered into on or before 31 December 2024, and you are not looking at renewing it or extending it during the 2024 calendar year, you can actually allow that arrangement to continue until 31 December 2024. However, if you want that arrangement to continue after that date, you do need to seek TPB approval. So we ask that you do that early to give you continuity. Now, if you do seek approval and the TPB does not approve that, you will need to consider your options to cease employing or using that entity from 1 January 2025. So that's how that transition period operates, where you've engaged someone on or before 31 December 2024. The second scenario that we have is where you're entering into a new or you're seeking to extend or to renew the contract during that transitional period. So in this case, you have to obtain approval from the TPB before you enter into that arrangement, even if it is during that transitional period. So Again, if that's approved by the TPB, that's no problem. You can continue with that provider. However, if it's not approved by the TPB, you will need to cease that engagement immediately. And you need to consider your options and how you can best do that. So hopefully those contractual clauses, those provisions in your employment, employer-employee agreement will allow you to cease that engagement immediately. So moving on then to, I guess, some more practical steps about how do you comply with Code Item 16 during the transitional period. As I mentioned before, it really, again, depends upon what stage of the arrangement you are currently in. So I think we all appreciate there's a lot of information that we've given you today. And what we ask of you, though, is to really zone in and work out what is the nature of your engagement. Have you already entered into it? Are you going to enter into it? And when did you enter into it? Once you know those elements, it'll be far easier for you to pinpoint exactly how you comply with these two new code obligations. So moving on then to the next slide, if we could. What happens then after the transitional period? So the transitional period will end on the 1st of January 2025. And essentially the only way for you to comply with Code Item 15 in situations where you do want to engage a disqualified entity is that you need to seek TPB approval. Now, again, if I could just emphasize again, for the purposes of Code Item 16, you cannot seek TPB approval. So in those cases, it's an arrangement you simply cannot enter into. There is no alternative option in that case. So earlier on, when I spoke about the example with Kim and Matt, and I had mentioned that there are actually also obligations that are imposed on Kim, who is the disqualified entity. So under the new law, there is actually an obligation on a disqualified entity to notify you as a tax practitioner in writing of their disqualified entity status. And they've got to do that at a time before you're seeking to engage them, and also where you're already in an arrangement where one of those events occur. Now, in those cases where the disqualified entity fails to give you notice, they could also be subject to civil penalties being imposed on them. And on the screen there, you can see some of those amounts, and they're not insignificant. We do have on our website a form that disqualified entities can use to notify you. So do have a look at that and provide that to any entity if it's appropriate to do so. I now might move on to discuss some of the notification obligations that exist. And this is probably the last part of the practical aspects of how you comply. So the process itself, I would say, to seek approval is actually relatively simple. So first, what you need to do is make sure that you obtain written consent from the entity that you're seeking to get approval for. And again, I mentioned before, we have that form available on our website that they can use to provide that consent to you to seek that approval from the TPB. The second thing that you need to do is to lodge your application with us. And you can do that quite simply by logging into your My Profile section on our website and access that approval form. Once we receive that, and assuming that we have all the information that we need, the TPB has to make a decision within 60 days of receiving that application, unless there's an agreement as to a longer period. It might be, for example, you're supplying more information or you're waiting for someone to come back to you, for example. But in most cases, we'll make a decision within 60 days. Now, if we decide to reject that application for approval, we will provide you with reasons for that decision. Further, if we don't make that decision within 60 days, your application is actually taken to be rejected. And that's really important because what it triggers are review rights for yourself, where you can apply to the Administrative Appeals Tribunal for a review of the TPB's decision. Now, I'll hand it back over to Peter in a moment, but I just really want to emphasise again that we've given you a lot of information today around how these two new code items operate, and we've tried to cover a lot of different scenarios. Now, not all of these scenarios, I would expect, would actually apply to you. So really our advice is to zone in on what your situation is when you're looking at engaging, at what point in time you're engaging, and that should make it clearer for you to understand exactly what you need to do to make sure that you don't fall foul of these two new code items, 15 and 16. So look, Peter, I might hand it over to you now to discuss aspects of our compliance approach and maybe share some case studies that we've got.
Thanks, Jeanette. And hopefully people will realise that the object of these new provisions is to keep people out of the profession that really shouldn't be in there in the first place due to their poor behaviour. But just moving on, from time to time, it will come to our attention that people have breached either code item 15 or 16. So we then have the capacity to issue one or more sanctions depending on the seriousness of the breaches. And one thing I'd say to you is that the seriousness of the breaches can be determined by the breaches alone, or it can be determined by a lot of surrounding facts about other things that practitioners may have done to breach the code, whether deliberately or unintentionally. So I think we take into account a broad range of factors. But in the event of non-compliance, we have the capacity to issue a written caution, to make a specific order, to suspend registration or to terminate registration. And the two lower end, the written caution and the orders, often we would make an order for a registered agent to complete a course of education, perhaps in ethical conduct or in the TASA or in work-related deductions or some of those sort of things, but depending on the nature of the breaches. But the written caution and the orders are for the less severe breaches of the code. And a suspension or a termination will come into play where the breaches are far more serious. And generally they're about doing two things. One is protecting clients or consumers of tax services from bad behaviour, and a suspension of an agent until they get their house in order can be very helpful in that regard. And a termination really is to say that that person shouldn't be practicing as a registered agent by virtue of their consistent bad behaviour. And they are really designed to do two things, as I said. Firstly, protect the consumers of tax services, and secondly, to protect the integrity of the profession overall. So that they're the broad sanctions that we have available to us. Sections or code items 15 and 16 can also be considered in relation to their impact on whether or not an agent is behaving with honesty and integrity, and whether or not the tax services are being provided competently to the public at large. And in extreme cases, we would consider whether the agent themselves is actually still a fit and proper person to hold tax agent registration. I'd like to jump forward to the next slide and just talk through a case study now, please. In the first instance here, we have a registered practitioner, Brendan, who wants to employ Chelsea to provide tax agent services on his behalf and under his supervision. So this is a standard employee-employer relationship. Brendan offers Chelsea a role within his practice and asks her to confirm that she's not a disqualified entity. Chelsea advises she's not sure. On that basis, Brendan has no further discussions with Chelsea regarding this question and employs her without receiving any further information. Brendan also does not conduct a POI check or a search of any of the public register, the TPB public register, to check if Chelsea's name appears as a terminated or previously sanctioned practitioner. In fact, Chelsea is a disqualified entity as her registration as a tax agent was terminated by the TPB approximately 6 months prior to her being employed by Brendan. It is clear in this set of circumstances that Brendan hasn't made reasonable inquiries prior to employing Chelsea and has not received our approval for Chelsea's employment. So Brendan is clearly in breach of Code Item 15 and may also be liable for a sanction and or civil penalties, which prohibit, because the TASA prohibits registered practitioners from employing or using the services of a deregistered entity within 12 months of termination of their registration. In addition, Chelsea may be liable for civil penalties for failing to notify Brendan that she is a disqualified entity before commencing employment to provide tax agent services on Brendan's behalf. Jumping forward to case study 2, we now have Trent, who is a registered practitioner. He seeks to use Winnie's services as a contractor to provide tax agent services on his behalf. Trent has undertaken a proof of identity inquiries in respect of Winnie and advises Winnie that he cannot use her services without TPB approval if she's a disqualified entity. Trent discusses the disqualified entity provisions with her and receives a written declaration from Winnie that none of those events apply to her. Trent also undertakes a search of the TPB register to confirm if Winnie's name appears as a terminated or previously sanctioned practitioner. The contract with Winnie contains a provision requiring Winnie to immediately declare if she is or becomes a disqualified entity. Trent has undertaken all the reasonable inquiries and met our minimum requirements. During the period of his contract with Winnie, Trent learns that Winnie was convicted of a serious taxation offence 3 years ago, making her a disqualified entity. Upon learning this, Trent immediately ceases using Winnie to provide tax agent services on his behalf. Accordingly, Trent has met all of his obligations under Code Item 15 and has not breached the code at all. However, Winnie herself may be liable for civil penalties for failing to notify Trent that she is a disqualified entity before entering into the contract. And in particular, this is aggravated by the fact that we didn't make that disclosure in circumstances where she was specifically asked. Let's jump forward into case study 3. Our next case study looks at Code Item 16. Here we have Frank, who had his registration terminated by us 2 years ago for ceasing to be a fit and proper person, making him a disqualified entity. Bonnie is Frank's wife and she is aware of his termination. 1 year after Frank's termination, Bonnie became a registered tax practitioner and at the same time also registered her company, Bonnie's Tax Proprietary Limited, as a tax agent. Bonnie is the company's sole director and supervising agent. It comes to our attention that Frank is meeting Bonnie Tax Proprietary Limited's clients in the office and preparing their income tax returns. These clients have only interacted with Frank, and Frank is also contacting the ATO on behalf of clients to arrange lodgement deferrals and debt payment arrangements. Bonnie's Tax Proprietary Limited is in breach of Code Item 16, as Bonnie, the sole director of Bonnie's Tax Proprietary Limited, is aware that her husband's registration was terminated, and Bonnie Tax Proprietary Limited has provided tax agent services in connection with an arrangement with Frank as a disqualified entity. Now, Julie, I'll hand over to you now so that we can look at some of the questions we've been receiving.
Thanks, Peter, for that. And thank you, Jeanette, for the presentation. We have had a lot of questions coming through. So just hoping, Jeanette, that you could give some clarity around offshoring arrangements for staff. We've had quite a few questions just asking if these code obligations actually are relevant to people that are working offshore or employing people offshore. Thank you.
Yeah, thanks, Julie. And yes, they are. So it's essentially if you're seeking to use or engage anyone that will provide tax agent services on your behalf, whether they're based in Australia or overseas, these same obligations do apply.
Excellent.
Can I just comment, Julie? That's
Sure.
a great question because those offshoring arrangements are quite common these days. And I think it really speaks to the heart of what Code Item 16 is about, where you're using external providers to provide those services, which is quite different to a set of circumstances where you're employing someone.
Great, thanks, Peter. Peter, I'll just ask the next question of you. You spoke at the beginning of the webinar just briefly about the breach reporting and self-reporting obligations that have come into effect. Just wondering if you could clarify the start date. There's a bit of confusion around that.
Yeah, so the breach reporting starts on the 1st of July 2024. And to be really seriously clear, it only applies to breaches that occur on or after 1 July 2024. So agents who are aware of breaches that occurred prior to that date, either by themselves or by other practitioners, don't have an obligation to report those prior breaches. It's only for breaches that happen on or after 1 July 2024.
Okay.
And
Sorry,
so,
Jeanette.
Julie, if I can just add to that, I think, Peter, that's a really important point. It's 1 July 2024 post situations. It's also limited to significant breaches of the code. So we're not seeking to have, sort of minor technical breaches being notified to the TPB. But I won't take up too much of today's webinar, Julie, because we've got a separate one on that one.
That's right. Thank you. And we've got lots of information on our website too about that. So if anyone's interested, you can jump on there and get some more detail as well. Okay, so the next question I've got here, Jeanette, I might ask this one of you. It's from Mark, and he's just saying that action taken against someone under the TASA seems to be a very broad definition. Tongue-tied. Does that include any action? Can you give us a bit more information about that?
Yeah, it does include any action, Julie. So that could include the TPB issuing them with a written caution. It could be the more formal sanctions, such as an order, a suspension, or a termination. But bear in mind that to be a disqualified entity, you cannot be currently registered with the TPB. So those kinds of sanctions will be focused on termination. Now, the other aspect of it, though, is that when the TPB gets an application for approval, the board, Peter and his team, they will look behind that and actually look at the conduct to determine whether or not that should be enough not to approve their application.
Great, thank you. The next question I've got is in relation to information that's on our TPB register. So I've got someone here saying that disqualified entities are only listed for 12 months on the register. They're just wondering, can this be extended to 5 years?
Great, thanks, Julie. Fantastic question. So some of the reforms that government has put in place or is currently consulting on, these were announced last year in August 2024. One of the enhancements that we are seeing is expanding the information that appears on the public register. And going forward, sanctions that the TPB imposes will appear now for at least a 5-year period. So that nicely aligns with these new disqualified entity provisions. So I think it's fair to say, Julie, just in time.
Yep. Excellent. Thanks, Jeanette. The next question I've got here is from Rob, and he's just got some concerns around fair work implications and sacking someone who's previously been a disqualified entity from a position. So he's saying that if information comes to light after employing them, does that have some issues around unfair dismissal laws?
Jeanette, do you want to do that or?
Look, I'll start off. You start off then, Peter. Go ahead.
The critical thing is to look at the transitional arrangement. So, if you had an employment arrangement in place with somebody before these provisions came into being, you've got to go through the transitional provisions. If you're employing somebody now, we strongly encourage you to make it clear in your employment contracts with people that these provisions exist and you have to be bound by them. Now, on that subject, I think employers need to be careful about how they interact with people and take great care to make sure that their terms of employment are fair and equitable. But as a registered agent, you must comply with these provisions. So we encourage you to use the transitional provisions, But if you are renewing a contract with somebody after the transitional provisions, you need to comply with the provisions, whether that be by requesting the TPB's approval for the appointment or by saying that you can no longer go on with that arrangement.
Yeah, I think they're great points, Peter. And if I can add to that, we at the TPB, we aren't specialists at all in employment law. So it might be an area that you do need to seek some separate legal advice on. But the one thing I would say is that the prohibition on engaging a disqualified entity is when they're providing tax agent services on your behalf. So I mentioned before that services that don't involve the provision of tax services do not capture the obligation under Code Item 15. So, you might want to practically consider what other things an employee, for example, might be able to assist you on in your practice.
I think,
Thanks. Yep.
Can I just clarify too, Julia? I mean, the object of these provisions is to take people out of the profession who are seriously not complying with their obligations under the code. Now, we can see some circumstances where a person might be a disqualified entity, perhaps by virtue of a personal bankruptcy or some other sort of problem, that we would sit there and say, well, we're not necessarily trying to ban somebody from making a living for that sort of individual problem. The ones that we really want out of the system are people who just don't comply with their tax obligations, who are not able to comply with the code of conduct obligations in the way they conduct their practices, who are clearly dishonest people. So in the first application that we received this year for the approval of the employment of a disqualified entity, we gave approval for that because we could see the circumstances of that person was that they were going to be okay to work under the real supervision and control of a genuinely compliant agent.
Thank you both for that. I've had quite a few questions around bankruptcy today as well, and I guess there's probably two main parts to it. First of all, does Code Item 15 mean that you cannot employ someone that is currently bankrupt? And then I guess the second part of it is around extenuating circumstances, and can there be any applied to people that have a bankruptcy situation?
Clearly, we would consider all of the surrounding circumstances in relation to the employment of somebody who is disqualified by virtue of their bankruptcy. And as I said, that can be for a range of reasons that doesn't necessarily imply absolute or dreadful dishonesty or bad behaviour. But it can be a set of circumstances where a person's bankrupt for, whatever reason. It might be a failed property deal or it might be some other problems. But if they're going to work in a good tax practice and they're going to be properly supervised by a registered agent, then we can see around those circumstances and allow that person to have a job. Again, I would sit there and say if the person had been terminated by the TPB for really bad behaviour in the tax system, we'd be pretty unlikely to approve that. But a personal bankruptcy without aggravating circumstances, I think there's a high likelihood of approval.
Yeah. So I think in response to that question, if someone is an undischarged bankrupt, they do meet the definition of a disqualified entity. Yeah. And so the only way you can engage them is to seek TPB approval. And I think if I can just echo what Peter is saying, is that when that application comes to the board will look behind it and understand how that bankruptcy arose, and where it doesn't impact on someone's ability to provide tax services, I think it's fair to say it's likely that the board would approve those applications.
Thank you so much for clarifying that. I think that makes it a lot clearer for everyone. The next question I've got here is around whether or not Code Items 15 and 16 have implications to other code items and potential compliance issues there. Could you talk to that a little bit?
I think clearly we're in a set of circumstances where if we find deliberate or lazy non-compliance with Code Items 15 or 16, we're going to consider those in relation to potentially other code items when we're imposing sanctions. So if we happen to see somebody who had been not providing services competently, or hadn't been putting their clients' interests first, or perhaps had been misappropriating refunds, what we do is we look at all of the circumstances to decide how bad the behaviour is and come up with the right sanction. If everything else in their practices is good and on foot, then your sanction might be a little bit lighter. But I think, clearly, whether you are behaving with honesty and integrity, if you're not complying with 15 and 16, we've got to think about how that impacts on honesty and integrity. And if you're deliberately trying to avoid 15 and 16, we've got to think about whether that is the behaviour of a fit and proper person.
Thanks, Peter. I've got a question here from Tanya, and it goes back to the register, Jeanette, which we spoke about just a little while ago. And this question is asking whether the register will be backdated to show the last 5 years if an entity is disqualified, or will it be for sanctions that have only occurred after 1 July 2024?
Yeah, so thanks, Tanya, for that question. There's a little bit of backdating. We look back to 1 July 2022. So that's what the government has decided by way of what's a fair period for look back.
Great, thanks, Jeanette. Next question I've got here is, can a BAS agent who's working under the supervision of a tax agent prepare tax returns for his clients and lodge them through the tax agent?
So in that case, it's actually the tax agent that's lodging the income tax returns, as much as I can understand with that example. So so long as they're appropriately supervised, then there is no problem with that. But if that BAS agent was to charge a fee for that lodgement of income tax return in their own right, they would be in contravention of the TASA, the Tax Agent Services Act.
Okay, thank you for that. I think we might just go with one more question. And this one is asking, should we now be doing checks on our current employees, especially if they have been with the firm for many years?
Yeah, my advice would be yes, because going forward, after the transitional period ends, you need to assure yourself that anyone that's providing tax agent services on your behalf is not disqualified. And where you do uncover something, you'll need to seek TPB approval. I know to some that might sound really onerous, but I think to Peter's point around making sure that the right people are providing tax agent services, it's also really important to remember that this process will also protect you and your practice going forward.
And Julie, can I suggest that within any practice out there today, there's quite a bit of change going on around the TPB and the TASA and the Code of Conduct. I mean, this is a great idea to have some internal training. It's a great topic for internal training. Now, if you run through this as an internal training product, at the end of the training session, you can look all your staff in the eye and say, now, is there anybody here that has anything they need to tell me? And that might be a really easy way to get the message out to your team. You've covered off on some of your CPE requirements. You're developing and protecting your own practice. And if one of your team has a problem, you can deal with that privately after the session.
Thanks. I think that's a good space to leave it today. Thank you to both of you for the presentation today. And I'll just finish up with giving some information on how to stay in touch with us. So if you do want to keep up to date, obviously our website, which we spoke about a lot today, is a great resource. That's tpb.gov.au. You can also follow us on LinkedIn, Facebook and Twitter. And we also have a newsletter that we issue each month called TPB e-News. And I'd highly recommend that you subscribe to that so that you're getting all the latest information. And once again, just jump on our website, tpb.gov.au/newsroom. And you can also subscribe to our YouTube channel, and that's where you'll receive notifications when we post new videos. And we do record all of our webinars. And as Peter said, this is a good resource to use for your training, but you can also claim CPE for viewing our videos as well. So once again, just a big thank you to both Peter and Jeanette for sharing their insights with us today. And thank you to Daniel, who's been assisting with answering questions throughout the session. We do hope that you've found it beneficial. And as we've said, you do have the opportunity to claim CPE for attending today, and you can claim 1 hour for today's session. So just one last point before we finish up, I will be launching an exit survey, and we'd really appreciate it if you could take the time to complete it. It's very quick. It'll only take a moment of your time, and the feedback that you give us is really helpful. It helps us improve on the webinars, but it also gives us some opportunities to find out what topics are of interest to you. So if you have some time, please complete the survey. It just pops up in your browser once you leave the webinar today. So thank you so much to everyone for joining us today. We do hope that you enjoy the rest of your day, and we'll talk to you again soon. Thanks, everybody.